So once again, good evening. I am the Reverend Jawanza Kareem Colvin, pastor here at the Olivet Institutional Baptist Church and a member of Greater Cleveland Congregations. First, let me say on behalf of the Olivet Institutional Baptist Church, our members, our leaders, and our staff, I want to welcome you and to invite you to make yourselves at home, make yourselves comfortable over the next 1 hour and a half. And if there's anything that our church leaders or our staff can do to help facilitate that, please let us know. Tonight, I see some very familiar faces, and I also see some old friends and some new faces in our audience. As a matter of fact, this week, Greater Cleveland Congregations is hosting a national training for newly formed partnerships with other community action organizations from around the country. And so I'm going to ask if you are a participating member of this national training and you're visiting with us from around the country, please stand so we can recognize you and give you a warm Cleveland welcome. Thank you very much for being with us, and we certainly hope that we made you feel welcome during your time over the last few days. This evening, we are here to address a very serious issue during some very serious times. We are mindful of crises that have captured our attention and also crises that go unmentioned and get no news coverage. Since 1931, this church, Olivet, has sought to place itself intentionally on the margins, where the struggle happens and where the struggling live. So we would be remiss if we did not start this meeting by placing our minds and our hearts for a moment on the margins. So right where you are, I'm going to ask if you would join me in a meditative moment of silence and centering as each of us, with our own concerns, with our own heartfelt grievances and pains, if you would bring into your hearts and your thoughts the faces of someone, of those living right now on the margins. Thank you very much. With that, I'm going to invite the Reverend James Cruz, one of the members of the ministerial team at the Antioch Baptist Church and a member of the GCC criminal justice team, to come and offer a word of prayer.
Good evening, everybody. I am James Cruz from the historical Antioch Baptist Church, and I'm a member of the GCC strategy team, and I'm also a member and the vice chair of the New Justice Power Alliance. Those are the folks who saw. Let us pray. God, you already know. God, you sit high and you look low. We're asking tonight that you touch the hearts of those whose hearts need to be touched. Open up their hearts, their minds, and their spirits, God, to help your people, guide your people, do what's right for your people. God, we are grateful for everyone here. We thank you for allowing us to be together one more time, that we may get it right, but you get the glory. We thank you, God, for everyone under the sound of my voice, and may you continue to bless everyone under the sound of my voice. We ask this in your name. Amen. We have a few ground rules. Oh, yeah. There's some ground rules. We started on time and we're going to end on time. You know, like Biggie Small said, this is what we do at this time. You know, GCC does that. Because the agenda is tight, there will be no opportunity for comments from anyone except the speakers on the agenda. However, we want to hear from you all. When you got your agenda and backgrounder, you also got a comment and commitment sheet. Is that right? Okay. We want you to write comments and ask questions, suggest changes. Please turn your commitments and comment sheets at the end of the evening so that we can learn from you as well as from everyone else. Thank you.
Hi, I'm Louise McKinney, a member of St. John African Methodist Episcopal Church and a co-chair of GCC's Pretrial Justice Action Team. Good evening, GCC. Great to see us all here. We're filling the church and raising the roof. Be careful though, it's a new roof. We love seeing our member congregations, Jewish and Christian, many denominations and traditions, and our other member organizations. Happy to see us here. We particularly want to welcome our invited guests who are here. Judges and judicial candidates and other public servants from the county executive's office and common pleas and municipal courts, the county public defender, a police chief, Cleveland City prosecutor and law director. Thank you for coming. Please rise and be recognized. Since its founding in 2011, Greater Cleveland Congregations has been an organization committed to building community power for change. With 39 member institutions across the city of Cleveland and Cuyahoga County, GCC brings together people across race, religion, region to take on tough issues like criminal justice reform, equal access to health care, and voter engagement. And over this time, we get real results that make a real difference. But why are we here tonight? I know why I'm here tonight. When I was a law student a half century ago, I learned the law and how to practice law. I also learned that law does not necessarily equal justice. But I wanted to practice justice. Before I retired from practicing law, GCC launched. Now I get to practice justice with GCC. So why are we all here tonight? Because we want to reduce jail before trial here in Cuyahoga County. Because jail before trial can equal pretrial injustice. Why are we even talking about jail before trial or pretrial detention? Well, we know we shouldn't lose our liberty without legal process, right? We know if they're in jail, people have lost their liberty, right? We also know that people are presumed to be innocent until they're found guilty. That's the law, right? But people are in jail before trial. Is that right? We know that 70% of people in jail in Cuyahoga County are there before trial, before a court proceeding establishes their guilt or innocence. Some of those people don't need to be in jail because they're not a threat to public safety. Jail before trial, as I said, can equal pretrial injustice, but that's not right. Tonight, we'll share why people are in jail before trial and how that hurts them and how it hurts our entire community. We're not just identifying a problem, though. We're sharing solutions tonight. The criminal justice system has alternatives to jail before trial. Those alternatives make sure people show up for their court dates, and those alternatives protect the public, all of us. We, people right here, can reduce jail before trial. The title of tonight's action is Jail Before Trial. We can do better. We must do better. We will do better. Let's go.
Good evening, GCC. Good evening, Cleveland. Good evening, friends. And so first of all, I am a Black preacher, so when I speak, you are free to speak back. Amen. Good evening. My name is Reverend Dr. Lisa Maxine Goods. I am a member of the GCC strategy team. I am the chair of our Battle for Democracy committee. I am a professor, a theologian, an activist, and the very proud pastor of the historic Shiloh Baptist Church of Cleveland. I am also a member of an organizing member of the Just Power Alliance. The core values of our nation to which we pledge purport a message of liberty and justice for all. But what liberty or what freedom is there for people who are held in jail cells, not because they have been convicted of a crime, but simply because they cannot pay for their own release? The foundation of our legal system is that all persons are innocent until proven guilty. Yet this presumption of innocence appears to be but a mere mirage, a fantasy, or an unattainable dream for persons who are held in a cold, dark jail cell, away from family, away from friends, away from their jobs, and away from society simply because they cannot pay for their own release before their actual trial. Tonight, I stand here with the Garner family because this is the story of my faithful member, their mother, their daughter, their sister, their cousin, their friend, Miss Tiffany Garner. Tiffany is a mother of 7 children, one of whom died at birth. She was a home health aide who was loved by her elderly clients. She was a lifelong member of Shiloh Baptist Church who marched in our drill team as a teenager and brought her children to church and vacation Bible study faithfully. Tiffany was not a saint. She was an ordinary person, just like you and I. She was just like most of us, a person who tried to make her way in spite of life's circumstances. But in 2021, Tiffany was the victim. Somebody say victim, not the assailant of a robbery. Subsequently, her assailant was assaulted by 2 unidentified men and succumbed to his injuries. Because of her struggle with the victim, Tiffany was brought in for questioning and arrested by East Cleveland police, by officers who we here in Cleveland know have now been convicted of numerous miscarriages of justice. While Tiffany was never, ever accused of assaulting the victim and therefore posed no risk to public safety, she was held in jail for over 2 months as she attempted to raise the necessary $25,000 for her release. I just told you she worked as a home health aide with 6 children at home, but she had to raise $25,000 for her release. Research consistently shows that people who are held in jail for even 3 days before trial suffer severe hardships that impact their lives and their families for years going forward. But Tiffany was held for over 2 months, 2 months away from her children, these children, 2 months away from her elderly parents and family, 2 months away from her job, 2 months away from her church, 2 months away from a society where she could actually actively participate in proving her own innocence. How do you actively participate in your own proving of innocence if you are locked in jail? During those 2 months, continuous attempts were made to coerce her into confessing to a crime that she did not commit. Attempts were made to coerce her into implicating people that she did not know by officers, and phone records were manipulated and used against her. During those 2 months, she lost her job. She could not pay her bills. Her 20-year-old son had to assume responsibility for his siblings. The church had to assist with her utilities. To raise bail, her parents had to take out a loan against their home. Her brothers took out loans. The family gathered every resource they had. The money designated for her legal counsel had to be diverted to pay for her release. As a result, she was unable to pay the retainer fees for the attorney of her choice. She lost her preferred attorney. She lost her rights and was forced to rely on the services of a court-appointed attorney who had not been with her from the beginning. Furthermore, having been in jail for so very long, she suffered irreparable damage in the court of public opinion. as the community assumed that she must have been guilty because she had been away for so long. They assumed her guilt and not her innocence simply because she could not afford to get herself out of jail. Most of her problems started with this unjust pretrial system. Do not get me wrong. I am an advocate for public safety and for victims' rights. As a matter of fact, Tiffany is an advocate for victims' rights as well. I lost my father to gun violence in an attempted carjacking many years ago, so I know firsthand the pain victims of crime feel. It is a club that I hope none of you ever have to join. But I ask you, how does holding people who are presumed innocent and pose no threat to society make our streets any safer? How does holding someone in jail because they cannot pay and releasing someone who can equate to justice? How is this justice? This is not justice, and this does nothing to improve public safety. It does nothing to make victims' lives better. These are injustices. This is not justice, and this does nothing to improve our safety. People like Tiffany, who pose no risk to society, people who are contributing members of society, raising families, and taking care of others. How is it justice for them to be left in jail pre-trial? Should they not have the right to liberty and justice for all? Should they lose their right to liberty and pre-trial justice just because they cannot afford to pay? We can do better. Families like the Garner family deserve better. I said families like the Garner family deserve better. These children standing behind me deserve better. These children, our society deserves better. Every person in our nation deserves better. Every person in Cuyahoga County deserves better. We will not have another Tiffany Garner who loses her rights because she cannot pay. Tiffany Garner is innocent. This we are sure of. But even as we continue to fight for justice in her particular case, we fight for pretrial justice for all Cuyahoga County residents because we can do better and we must do better for our citizens. Somebody else say we can do better. We will do better. We can do better. And we will do better. Thank you.
And Tiffany's beautiful family. $1,441. This evening, you'll hear many numbers around jail before trial.
Because of the photo that you're seeing here. But the truth is, we've had a lot of big changes in our history.
Alive, a Myers, or a Cody. They could be your family member, your church member, your neighbor, your coworker. Good evening, I'm Charnel Woods, a proud member of the Antioch Baptist Church Social Justice Ministry and the GCC Pretrial Justice Action Team. This is important to me because I truly believe that we are indeed our brothers and sisters keeper. You just heard firsthand how the harms of jail before trial can affect the incarcerated persons and the family. But did you know that the harms of jail before trial extend to our community and even our society? 3 days. Just 3 days in jail can uproot a person's life. You know what it's like to miss 3 days of work? Some jobs even require a doctor's note. This is much more severe. Just 3 days in jail can bring so many harms to affect a person. Harms to one's physical health by worsening chronic conditions like asthma, having no medications, and the ultimate harm, death. Harms to mental health by increasing the likelihood of suicide and long-term mental instability. Harms to life definition, creating an overall loss of personhood. Who are you when you lose your family, the custody of your children, your life's income, job, housing? Harms to your finances, indebtedness due to bail, court fees, and attorney fees. Besides the incarcerated person, harms extend to the family. You heard what happened to Tiffany's family. Her indebtedness was passed on to the family, requiring loans to be taken out, undermining the stability of the family and the community. Now, in this family picture, there's someone missing, whether it's a parent or other family member. Those missing persons are higher because of the disproportionate charging of Black and brown people. This plays a role in normalizing the involvement in the criminal justice system, leading to a self-fulfilling prophecy in youth and community members of their worth and future place in society. With families destabilized because of a lessening or loss in income, the community is also affected. Now, one may wonder, how can jail before trial affect the legal system? Because it rips at the very fabric of a system that says you are innocent until proven guilty. It puts into play situations where people take plea deals just to get out of jail conditions. 95% of cases are solved through plea deals. People like Tiffany are incarcerated until they aren't even proven guilty. And this leads to people even being the charges dropped, although they serve time. The presumed innocent, like Tiffany, continue to be incarcerated, only to have their situation worsen. Now, 2 days in jail increases the likelihood that they can be arrested for a new offense. Now, remember, we're not talking about convicted criminals, but presumably innocent people. The list keeps growing. If you are a taxpayer, you are affected by the harms of jail before trial. Your taxes paid to house and supervise the incarcerated, and to provide public help for families who are spiraling into loss. If there's any doubt that we must continue to improve jail before trial, know that jail before trial mocks the pledge that we make, liberty and justice for all. Dr. King told us decades ago that justice too long delayed is justice now. Let's stop denying Tiffany and our brothers and sisters the justice they deserve.
Thank you, Charnel. And good evening. My name is Pat Dillard, and I'm a member of the GCC Pretrial Justice Action Team and the Unitarian Universalist Congregation of Cleveland. We know that we are causing harm both to individuals and our community. We've made some progress in Cuyahoga County, but there's so much more we can do together. And you've heard this before, but on April 11th this year, we had 1,441 people in our county jail. And 70% of those people held in our jail were there before the court had decided their case. Why are these people in jail? It's not for punishment because they have not had a trial and they've not been convicted. Let's look at 5 reasons people are in jail before trial. And imagine if this happened to you or someone you love. One reason people are in jail is because they cannot afford to pay bail to get out. However, the court has alternative methods to keep a person in jail who is determined to be a flight risk or a safety risk to the community. Another reason people are in jail is because judges may have insufficient information to determine public safety risk. A non-biased and locally validated assessment tool will provide reliable information. And third, we know that mental health and addiction services are best provided in the community, not jail. According to recent studies, the majority of people in the United States jails have a diagnosis of mental illness or substance abuse disorder, or both. GCC worked with the county to get the Crisis Diversion Center up and running. Now, the Crisis Diversion Center needs greater utilization by the police to fulfill its purpose. And fourth, people who are arrested for a nonviolent charge do not need to be kept in jail. As many districts all across the country are doing, they can be given a court date and released. And the fifth reason people end up in jail is because they miss a court date or fail to follow other court requirements. The process in which a person is arrested for not meeting court obligations is called a bench warrant. The result of a bench warrant is that a person is sent to jail and may stay there for the remainder of their case. We can reduce the number of bench warrants by providing support services, such as personal phone call reminders and transportation for people released from jail so that they can meet their obligations. Our county has started to take one major step to reduce jail before trial. It's called central booking. Its purpose is to provide more informed and timely decisions about diversion, charging, and release of people from custody. However, it has not yet lived up to expectations. So why does all this matter? The late Paul Farmer said, "The idea that some lives matter less is the root of all that is wrong with the world." I care about what's wrong with the world, and I know you do too.
Good evening, everyone. My name is Patty Comperta, and I'm a member of both Lakewood Congregational Church and the GCC Pretrial Justice Action Team. I have the privilege this evening to introduce our next presenter, Ms. Jessica Ireland, who is a senior manager at the Center for Effective Public Policy. The CEPP works towards helping to create a world where all justice is community justice. It helps practitioners, policymakers, and communities reimagine a justice system that works for all. She is a national expert on pretrial services programs, collaboration in the criminal legal system, and implementation of sustainable and effective pretrial system improvements. Ms. Ireland was the pretrial services program manager for Mecklenburg County, North Carolina, where she spearheaded efforts to improve the efficiency and effectiveness of pretrial screening, release, and supervision practices, which, under her leadership, helped Mecklenburg County become the first standalone jurisdiction to receive national accreditation from the National Association of Pretrial Services Agencies. Not yet. In Jessica's current role, she helps jurisdictions nationwide make pretrial improvements, focusing on enhancing pretrial services and implementing actuarial risk assessments, especially the PSA, the Public Safety Assessment. She holds a Bachelor of Science degree in criminal justice and a master's degree in public administration, both from UNC Charlotte. She lives in Denver, North Carolina with her husband and 3 children. May I present Jessica Ireland.
Thank you for that introduction, and thank you for inviting me to speak with all of you today. It truly is an honor to have the opportunity to discuss pretrial justice with such a distinguished group of individuals. Pretrial justice is a topic that I am incredibly passionate about because there are so many opportunities for communities to work together and do better for people who are in jail before trial. In recent years, nearly all of the growth in jail populations has been driven by pretrial detention. In fact, in recent years, the number of people that have not been convicted has steadily increased in jails across the country. It is often pretrial policies and practices that drive jail detention. Nationwide, people detained pretrial now represent approximately 2/3 of the jail population. For these and other reasons, many counties, municipalities, and states are interested in improving their pretrial systems. Pretrial policy and practice changes can significantly impact your local jail population. They can also improve public safety and court appearance. Over the next 10 to 15 minutes, I plan to highlight several best practices from a national perspective that help promote pretrial justice. There is no single answer. It often takes various pretrial policy and practice changes to improve the pretrial phase of the criminal legal system. The best practices I plan to highlight include pretrial services, actuarial assessments, supportive services, and data. My goal is to inspire you to think outside the box and identify ways you, as a system, can work together and do better for your community and people in the pretrial phase. I want to be clear that I am not the expert for your system. You are. And I'm not here to tell you what to do. I am here to share best practices and encourage you to consider whether there is an opportunity for improvement in each of these areas. Any effort to make effective and lasting change requires the active participation of all stakeholders, including, at a minimum, judges, prosecution, defense, police, sheriffs, pretrial services, victim advocates, county administration, those impacted by the system, and the community. The fact that GCC organized this summit and invited all of us here shows me system stakeholders are interested in working together to do better and implement effective and meaningful changes in Cuyahoga County. That's right. The first best practice I want to talk about is pretrial services. In many jurisdictions across the country, pretrial service programs have been implemented. I believe in Cuyahoga County, you offer pretrial services in your common pleas court. Effective and robust pretrial programs can work to safely reduce the jail population and limit unnecessary pretrial detention. And when I say unnecessary detention, I am not implying that every individual should be released. Some individuals pose significant threats to public safety and the community. But in almost every jurisdiction I have worked with, their pretrial jail population mostly consists of individuals charged with low-level offenses and failure to appear, those that could safely be released. The National Association of Pretrial Services, or NAPSA, identifies two primary roles of pretrial agencies. The first is to assist judicial officers in making informed release decisions that promote court appearance and public safety. And the second is to offer support to those released who would benefit from services. NAPSA is not the only organization that discusses pretrial services. The American Bar Association also weighs in on the role of the pretrial services agencies. ABA calls for a pretrial program to present information relating to failing to appear in court and threatening the safety of the community. But that's not all. Pretrial services must also work to promptly release individuals who have been ordered to pretrial programs. This is so important because there is a growing body of research that demonstrates jailing people before trial does not deter future crime. And actually, it may undermine community safety. The Hidden Cost Revised is a report based on data from nearly 1.5 million people booked into jail in Kentucky between 2008 and 2018. The key findings are noted here. Pretrial detention for any length of time is associated with a higher likelihood of arrest for a new crime before case disposition. And pretrial detention is associated with an increased likelihood of receiving a sentence and a longer sentence compared to those who were released pretrial. So some people may be wondering, why is it that pretrial detention is associated with an increased likelihood of receiving a sentence and a longer sentence? Well, I want you to think about it. When you're released into the community, the defense lawyer is able to go to the prosecutor and say, let's reach a plea here. My client has been safely in the community, doing his or her job, taking care of their family, getting an education, and coming to every court hearing. That is very, very powerful to prosecutors in figuring out a plea and to a judge when deciding a sentence. Having a pretrial program that provides objective information and offers supportive services to individuals in the pretrial phase is embedded in national standards and is key to success. And remember, once a judicial officer decides to release, it must be done quickly to reduce harm. That's the first best practice. The second one I want to talk about is actuarial assessments. These assessments are the primary way pretrial services can assist the courts in making more informed release decisions that do two things: promote court appearance and protect public safety. Assessment should be completed on all individuals appearing before a judicial officer for a release decision. And the key word here is all, a concept known as universal screening. So you might be wondering, what is an actuarial assessment? So when I say actuarial, I mean a tool that has been statistically proven to predict pretrial outcomes, meaning court appearance and no new arrest. Actuarial pretrial assessments estimate the likelihood that people will appear in court for pretrial proceedings and remain arrest-free while on pretrial release. These assessments are developed using large data sets about people who previously came into contact with the criminal legal system to identify factors that are correlated with a lower likelihood of pretrial success. The assessment provides decision makers with information about how people with similar profiles to the person in front of them have performed on pretrial release. Empirical research demonstrates that assessment tools do a good job of predicting court appearance and no new arrest, and they predict more accurately than human decision-making alone. Research also finds limited, if any, predictive bias, and assessment tools do not appear to exacerbate existing racial disparities. Absent an actuarial assessment that estimates the likelihood of these factors, judicial officers are relying on their professional and personal judgment, which can introduce implicit bias and other subjective measures. So as we talked about, actuarial tools help measure the likelihood of pretrial success. In Cuyahoga County, some courts receive the ORAS, or the Ohio Risk Assessment Instrument, and others the PSA, the Public Safety Assessment. Both are actuarial assessment tools, although there are key differences, and what I'm going to highlight is the PSA. I like this actuarial assessment tool for a few reasons. It was developed using data from 750,000 cases across the country. The researchers tested hundreds of factors for their statistical relationship to pretrial outcomes and found the most predictive factors related to the current charge, criminal history, and age. From there, the factors were validated on an additional 500,000 cases. The PSA does not require an interview and has been validated in dozens of jurisdictions across the country. The assessment tool consists of 9 factors, all of which are derived from the adult criminal history. What is really unique about the PSA is that it predicts the likelihood of failure to appear and new criminal arrests separately. It also identifies those that have a higher likelihood of being arrested for a new violent offense while on pretrial release. But I have a few slides that I'm going to walk you through that help illustrate this a little bit more. So this slide that you're looking at highlights the success rates from the development and validation of the PSA. The way to read this is that an individual with a scaled score of 1 on the PSA is likely to appear in court 89% of the time, and an individual with a scaled score of 6 is likely to appear 65% of the time. You interpret the likelihood of remaining arrest-free the same way. An individual with a scaled score of 1 is likely to remain arrest-free in the pretrial phase 91% of the time, and an individual with a scaled score of 6 is likely to remain arrest-free 47% of the time. But that's not it. This last slide shows you something that I think is really unique because the PSA also provides a violent flag for individuals who have an elevated likelihood of being arrested for a violent offense in the pretrial phase. Again, using data from the development and validation of the PSA, this chart indicates those who did not receive the violent flag, the bar at the top, did not get rearrested for a violent offense 98% of the time. And those that did receive the violent flag, the bar at the bottom, were not rearrested for a violent offense 92% of the time. So the big takeaway here is that most often in the pretrial space, people are not rearrested for a violent offense. Right, you wouldn't believe that if you read the media. You would think that that's not what is going on, but statistically speaking, that is very uncommon. One of the key takeaways is the PSA allows you to focus on success by highlighting the likelihood an individual will appear in court, the likelihood they will remain arrest-free, and the likelihood they will remain violent arrest-free. This information is shared with judicial officers so release decisions can be made that are least restrictive and focus on promoting pretrial success. Consistent use of an actuarial tool can assist in making more informed and consistent release decisions. This makes me think of Tiffany, who sat in jail for a long time because she couldn't afford to post her bond. I'm sure on an actuarial assessment, she would be a 1-1, indicating she had a high likelihood of success and could be released. The third best practice I want to highlight is supportive services. The key here is that services are voluntary and individualized based on the needs of the person. In many places across the nation, the services and interventions that the criminal legal system provides to people on pretrial release are undergoing a transition. In the past, these services were primarily focused on monitoring and enforcing compliance with court-ordered conditions. Today, many agencies are moving away from this model and are focusing on assistance and support. This change is the result of the field's understanding of pretrial legal principles and research, a recognition that pretrial supervision is not the same as probation and legally cannot be used as a punishment, and an urgency to achieve more fairness, consistency, and economic and racial equity. Supportive services are offered by court programs, pretrial service agencies, and community-based providers. They vary in type and scope, but they all have one thing in common: a focus on helping people succeed while on pretrial release. Common supports include housing, transportation, childcare, and service referrals. I love this picture because I think it illustrates the point very nicely. Each person in the pretrial phase, there's the picture. Each person in the pretrial phase is trying to achieve the same goal, but they each need something different to reach that goal. If the goal in the pretrial phase is to appear in court and not be rearrested, it's important to realize that different individuals will need different supports to reach that goal. Here is another way to think about supportive services. So I want you to look at this question. When you have a tough day and want to lift your spirits, what do? For me, when I have a tough day, I grab my sneakers, I grab my earpods, and I go on a long run by myself because that's what I need to lift my spirits, right? So I want you to raise your hand. How many of you are going to grab your sneakers and go on a long run? Okay, a few. I see a few of you. Very good. All right, but definitely not all of you. And that's exactly the point. The point here is that we all need something different to lift our spirits. Just like people in the pretrial phase all need something to help them succeed. Individual supportive services are paramount to helping people be successful in the pretrial space. Based on available statistics, people impacted by the pretrial system have significantly higher rates of health, social, and economic issues than the general population. These include, but are not limited to, homelessness, mental health, and substance use. Pretrial service programs are ideally situated to serve as a navigator or connector and help people gain access to needed services. As a community, it is important to actively work to identify the various supports that are available for people in the pretrial phase. And lastly, I want to touch on data. Making criminal legal system data available and accessible to system stakeholders and the community is essential to achieving pretrial justice. With reliable data, a jurisdiction can review outcomes and measure its performance. Data allows a team to determine to what extent they are meeting their pretrial goals. Some common data questions to answer include: how many people are being released and detained, and what are their charges and demographics? To what extent are people on pretrial release remaining arrest-free and appearing in court? And how has the jail's pretrial population changed in number and type since new policies were implemented? Using data to answer these and other questions expands people's knowledge beyond anecdotal information and provides them with a more complete understanding of their pretrial system's strengths and opportunities for improvements. As advocates have stated, any attempt at real, lasting change will require a significant investment in our ability to collect, store, and share data. We cannot confirm that new policies work without tracking their outcomes. We cannot address racial injustice without data about policing practices, court processes, and jail populations. With access to pretrial data, people can measure the success or failure of changes. However, most jurisdictions do not currently have this ability. Therefore, any effort to improve the system of pretrial justice must be accompanied with an investment in data infrastructure to ensure that system stakeholders can measure their performance, see their problems, identify the solution, and most importantly, hold themselves accountable. This is an example of what pulling data together, you like that, right? Hold people accountable. All right. This is an example of what pulling data together in a meaningful way could look like. This is a report, a public-facing report in one of the jurisdictions I work with out west. You can see their pretrial success rates, appearance rates, and no new case rates. And this is just a sample of what anyone in the community can go on and look at. I encourage all of you to break down silos that often exist in the world of data and come together to identify what performance measures are important, how you are going to collect data, and how you will share this information. And remember, transparency is key. You have to share this information. So in closing, I am excited at all the potential you have here in Cuyahoga County and what great opportunities there are for you to come together and work to implement lasting change. I encourage you to think about your current practices and if there are any opportunities to do better. I look forward to hearing about all the great pretrial improvements you make in the future. Thank you again for letting me talk to you tonight.
Please join me again in thanking Jessica Ireland for coming from all the way from North Carolina to share with us for her expertise and best practices. We thank her and we look forward to working with her over the next several months to come. I want to quickly transition to our panel. We have people who are engaged in this work, both researching, also as practitioners, and we want to give them an opportunity to weigh in from what they see at their level of involvement and research and engagement. And so I'm going to take time now to introduce quickly our members of our panel discussion. One who is actually joining us from Zoom, Rachel DeSalle. And Rachel DeSalle, is she here? Is she here with us?
Certainly am.
There she is. How you doing, Rachel?
I'm so glad to be here from New Orleans. Didn't want to miss it.
Great. Rachel is and has for more than 2 decades been reporting on the justice system. Currently, she is the community and special projects editor for Signal Cleveland and a contributing editor for the Marshall Project Cleveland, where she focuses on including voices in the criminal justice system reporting. Ms. Rachel DeSalle. We also have with us the Honorable Judge Michelle D. Early. Since 2009, Judge Early has served on the bench of the Cleveland Municipal Court, and since 2017 been in the role of administrative and presiding judge, making her responsible for the business and the overall direction of the court. Judge Early. We have with us Mr. Russell Tye. Mr. Tye is the Chief Trial Counsel at the Cuyahoga County Public Defender's Office. He brings to this role nearly 3 decades as an attorney, serving as a defense attorney, a prosecutor, and currently a member of the Public Defender's Office. Mr. Russell Tye. And Ms. Tammy Sherman. Ms. Sherman is Chief Probation Officer for Cuyahoga County Court of Common Pleas. Prior to this, she served as one of the first lead officers in the probation department, where she supervised the court's GPS unit and was responsible for the development and implementation of the court's active GPS monitoring program, Ms. Tammy Sherman. We want to thank all of our guest panelists for accepting our invitation to participate in this forum and this panel. And what we hope to gain is better understanding of the role that each of them play in the pretrial process, their efforts in that role to improve the system, and ways we can further these reforms for a more fair and justice system. For an explanation of our format, for the purpose of time, we've asked all of our panelists to limit their responses to 4 minutes. And if we have time, we will have a follow-up or two if time permits us to do so. But to provide some context, I'm going to ask Ms. DeSalle, who's joining us via Zoom, what changes have you seen in the County Common Pleas Court, and how would you assess these changes in comparison to some of the national best practices for pretrial services that we just heard mentioned by Ms. Ireland?
Yeah, thanks for asking. So the Marshall Project where I work, we dug into this issue last year, and our reporting analyzed bail decisions in about 70,000 felony cases over a 7-year period. So overall, there is some positive news. The County Common Pleas Court has significantly reduced the number of people in felony cases who are in jail before trial. That impact that we found was most significant for people facing low-level and non-violent charges. So think about theft charges and drug charges. I think kind of before we move to the what's next part, it's important to acknowledge that. However, there are people who do still have to pay bail, millions of dollars worth of bail each year, and folks who can't make bail or who aren't released from jail because they can't afford to pay for GPS, or maybe they don't have a stable home address. The other thing to know, and I think this is really important for this conversation, is that the changes that we have seen, the changes that have happened, they're not systemic, they're not concrete, and they're not yet consistent. So in other places that have really focused on pretrial justice or bail reform, these changes have come by way of new laws or by way of lawsuits or really significant policy changes. Here in Cuyahoga County, we have a system where the city where a person is arrested and the judge who sets their bail still has a really big effect on whether they sit in jail before trial. The Common Pleas Court has attempted to, I would say, level the playing field by finding ways to quickly revisit bail that is set in some of the municipal courts across the county, see if there's a way to lower it in some cases, but still, the initial bail that's set in Cleveland, which uses a bail assessment, might be far different than the bail set by a judge in East Cleveland or in Berea, even for people facing the same charges. And what that means is that justice is not equal. Even within the Common Pleas Court, the changes that I'm mentioning are precarious. Depending on the judge who is drawn to set the bail might be different. And so, as we were reporting, we realized that we wanted to figure out how these changes happened. And I was really surprised that the changes were not written in policy or they weren't court rules, they were verbal. So the court's leadership, elected judges, basically told one person called the bond commissioner to start recommending personal bonds in lower level cases that did allow more people to be released without paying money. Because judges often took those recommendations, but not all the time. Judges still have a lot of discretion, and they don't use a system like we heard about previously, where they're really using data to see whether a person should be released. So years ago, advocates, news outlets, and the court started to examine this issue, and there was an expert report, and I think it's a good time to return to it. So it determined that for reform to be effective and lasting, it needed to be system-wide. Couldn't just be in one court. And that report laid out a roadmap for reforming the system. And a few of the suggestions stuck, but some of the larger systemic change hasn't happened. Instead, it's been more like a series of tweaks. And why is that? I think this is actually the perfect time to ask that question. Is it politics? Is it power? Is it the fear of voters' perceptions? Or is it money? Because it would take a significant investment to pay for countywide pretrial services. Another reason is that the people who are being harmed by the system most often are residents who are Black, who are poor, people who struggle with mental illness, or who don't have stable housing. So I think, like I said, this is a really good time to ask those why questions and then consider what the next steps should be.
Thank you very much. Judge Early, what efforts has the Cleveland Municipal Court made to reduce jail before trial? And as a part of that, could you expound on the motivation behind some of the actions the municipal court has taken?
Good evening. So before I kind of talk about what Cleveland Municipal Court has done, and I actually became the administrative presiding judge in 2018. I gotta first talk about, it wasn't what we did, is the fact that we got together and talked about why we needed to do something. So we collectively, and I have a lot of my colleagues here. I see Judge Groves, because she was one of the people at the table, very aggressive, and I love it. Judge Moore. So we talked collectively about the why. So we agreed that it was important to address the number of people who are being held before trial because they were, not because they were dangerous or because they were high risk, because they were poor. So we started off with that conversation of, us not wanting for that to be what Cleveland Municipal Court looked like, how we were not having people in jail, again, not because they were dangerous or because they were at high risk, but because they could not afford to pay. So we all kind of got on the same page there. And that kind of allowed us to push through the how, because at the end of the day, we may not have agreed with the minute steps and all of the details, but it always defaulted back to the why. And that kind of helped us push through to getting to a place of what we were doing at the time. And that was looking at cases and believing that we were doing the best thing at the time. And then looking at where we wanted to be and knowing that we needed to go further than that. That brought us to a place to have conversations about utilizing risk assessments. And we utilize Arnold Foundation Public Safety Assessment. Is it perfect? It is not. But it put us in a place where we were getting information that would allow us to make appropriate release decisions. We got to a place where the people who were at high risk was, we knew what was going to happen there, what we're going to do, and the low risk, but there's an area in between. And we realized that we could do more to release more people if we minimize the risk. So there are people and we actually utilize a public safety assessment that was on the board. So that was good to see. Because if you put up something different, it made me afraid. So I appreciate it. So we do utilize that. And that does talk about the likelihood to appear, the likelihood to commit new criminal activity. And when we got to the space in the middle, there was still an area of risk. And that's where we decided to create the pretrial services department and provide GPS monitoring, supervision, and return to court reminders. That kind of helped us in our efforts to get more people to come to court and have less people who are reoffending. Real quick before our time runs out, we do public safety assessments on all the individuals who appear before the court. That's 4,814 people are the number of individuals we did the assessments with. A little less than 1,800 were misdemeanors. Out of those people, we've been able to reduce our failure to appear rate to less than 25%. Prior to COVID, it was like maybe 18, 19. So we still got to work our way back to that area. Most significantly, though, we've had 4% of those people last year commit new criminal activity. So out of over 1,500 people, only 63 people committed new criminal activity. Only 7% of those people were non-compliance that would be entering an exclusion zone or not coming to court. So out of over 1,500 people, we've had 109 people who weren't compliant, but everybody else was. So, we really believe in this program. Again, can we tweak it and make it better? Absolutely. But, for us, we needed to do something. And while we were doing this something, we kind of figured it out. But again, for Cleveland, we agreed on the why, and that took us to kind of shaping the how. And we're still working on that. Pre-service director is here. The one sitting behind him is the one the county took from me. And it's our overall goal to increase the amount of resources and services that we can provide to the individual pretrial.
Thank you. Mr. Ty, what role does the Public Defender's Office play in reducing jail before trial, and how can a defendant's lawyer effectively advocate to improve their client's chances?
Good evening, everyone, and again, thank you for having us. I think it's critical that attorneys, public defenders and attorneys in general, private practice and assigned counsel have to, first of all, care about their clients. That's first and foremost. Okay. You have to get to your clients early and get to the stakeholders early so that your client will have an opportunity to get out of jail sooner rather than later. It saddens me to hear stories that we heard earlier about this lovely family, Tiffany, who spent so much time in jail. And that's what we try to eliminate in our office. And I can say candidly that even private counsel throughout our county has done a great job at trying to get to their clients early. And I can speak from a private perspective in that I spent almost 17 years in private practice. And I'm actually honored to work under Cullen Sweeney and with the Public Defender's Office now, and try to take my efforts in making sure that people get out of jail early. Sadly enough, we see it way too often. It has been repeated, the theme throughout this process. So what we have done, we created 2 positions in our office a couple of years ago, knowing that there was a need for us to get to our clients earlier. We got what's called intake specialists, 2 hired full-time positions that work closely in the arraignment room, in the 3D room where Judge Early talked about earlier, about where bonds are actually set. We get to them early, we interview them on an intake form and make sure we get all their critical background information. For example, if they're working, if they have any other obligations out in the community that we can talk to the judge about, and get that background information to the judge early enough so that they can recognize that this is a person that deserves to be out on bond and shouldn't be held pre-trial simply because they can't afford it. So with those 2 persons in our office, they do the interviewing real quick so that the judge is well informed when they make a bond decision. The second thing we have done is implemented a close relationship with the Bail Project. For those of you all who do not know what the Bail Project is, it's a very critical organization that really helps people post bond. They are critical in the analysis. We actually have a bail disruptor, which is a person that will do the interviewing, do the legwork, go out there and interview the client very early on to get their background history, to get, again, to judges like Judge Early and our common pleas judges, to let them know that there is in fact a person that deserves to be out on bond. Now, we are very cognizant of the fact in our office that not everybody can make bond. And that's the gray area that Judge Early and yourself has mentioned. There are persons that we firmly believe if we were to do something better in the future, and that simply is to make sure we catch some of those people that are maybe a little bit higher charged, because so often those people are sitting in jail and are found not guilty, or the cases may be dismissed for some reason or another. We also work with Cleveland State University. They have a pretrial clinic where the students are embedded with us to help work with clients and make sure we get their bonds lowered. We also do things when we have to. We'll even go to the Court of Appeals, which is our higher court. If we file bond motions and the judge that's assigned to the case denies the motion, or we don't get a motion that was granted low enough for that person to get out of jail, what we will do then is go to our Court of Appeals and make that argument and do what's called a writ of habeas corpus to get them out of jail. And we've actually been very successful in that effort. That's all the time I have. I thank you for having us, and I will pass the
Thank you, Mr. Todd. Ms. Sherman, we heard earlier in Ms. Ireland's presentation a focus on assessment, supervision, support services, and data, and we know that you work particularly in the area of supervision. In your role, what have been some key steps that have been taken toward improving our current system of supervision?
Good evening. Thank you for having me here today and including Common Pleas Court in tonight's forum. On behalf of our administrative and presiding judge, Brendan Sheehan, I want to share with you his disappointment that he was unable to attend this evening. Judge Sheehan is out of town with his family, but wanted to express his thanks for this opportunity. To answer your question regarding the core aspects of pretrial service, that is assessment, supervision, support services, and data, I will address them independently. We are very proud of the work we do in Common Pleas Court. As to assessments, the court utilizes the ORAS pretrial risk assessment during the pretrial phase. This tool was validated by the University of Cincinnati and is designed to predict both a defendant's failure to appear and risk of violating pretrial supervision with a new offense. While an assessment tool can be useful, it is just one factor that is used by our judges to determine appropriate levels of bond and pretrial supervision. Two recent changes to Ohio's Constitution impact decision-making from the bench regarding bond decisions. The requirement to consider public safety when setting bond and the requirement to allow victim input into any decision that impacts the release of bond. As to supervision, our court has utilized pretrial supervision since the early 1900s. Since the early 1990s. And I have to slow down, I'm sorry. Our court has utilized pretrial supervision since the early 1990s, and we continue to modify the way we supervise individuals who have been released on pretrial. I am particularly proud of our use of GPS monitoring. The court does not charge individuals who are in a pretrial status for GPS monitoring. At the conclusion of the case, if the person is found guilty, the judge can waive the GPS fees altogether or allow an individual the opportunity to perform community service in lieu of those costs at a rate which we just increased of $15 an hour, which is higher than the state's minimum wage. Individuals placed on pretrial supervision, or what we call court supervised release, are assigned a pretrial officer who address barriers individuals may face, such as housing, employment, substance abuse, and transportation. Currently, we have 876 individuals on pretrial supervision. Of those, 460 are on court supervised release, 400 are on pretrial GPS supervision. Support services that we are implementing, we have a texting program for individuals to receive notification to court appearances. We provide bus tickets to people who lack transportation and also lift to our specialty dockets. We screen individuals at the time of arraignment for referral to our specialty dockets. And we also work with the Build Project to provide pathways for individuals to utilize their services. I have to wrap it up. And there was a lot more information I wanted to share. But my approach can be best summed up in a quick story that one of our judges used to describe my management team. A woman made a roast for dinner and would always cut it in half before she cooked it. One day her husband asked her why she did this. She thought about it and said it was because that's what her mother always did. She called her mom that night and asked her why she cut her roast in half. Her mom replied that she wasn't sure she had done it because her own mom had done it that way. Her grandma responded that when she was first married, she never had a pan big enough for the roast, so she would have to cut it in half. I am proud to say that we are much like the woman in the story. We continue to ask questions and make changes where it is necessary to fulfill the mission of our court and probation department. I would like to also add that my probation management team is here with me. That is those are Deputy Chiefs Reese Tucker, Michael Cooney, and Stephanie Pope Early. Thank you.
Please join me in thanking each of our panel participants for this very informative discussion.
That was good. That was good. We have heard how and why the system of pretrial service can get better. We have heard the harms of jail before a trial and how 3 days in jail can damage a family, cause a person to lose their job, and put their children in harm's way mentally and emotionally. We have heard Mrs. Jessica Ireland about cities that have implemented new structures in their pretrial justice service that have improved tremendously. Cuyahoga County Courts knows this is a problem and has done some things to make it better, and there is an opportunity to build on this momentum. We have heard that it starts with 18 judges to agree and develop the formal rules. Our county needs to develop a comprehensive pretrial justice service that has comprehensive pretrial services that set people up for success, strong assessments that gives timely and accurate information about a person's potential to commit crimes in the future, support services that look at childcare and housing, transparent and accessible data for everyone involved in the pretrial system. We have heard that the people running Cuyahoga County courts matter because they shape the policies of how people who cannot pay to get out of jail are treated. The bottom line is it takes judges, prosecutors, private bar, public defenders, bond commissions, sheriffs, police officers. It will take all of us to create a criminal justice system that sets people up for the success, not just punishment. We can do better. We can do better. We will do better. We have heard how it also takes political will and money, which the city, the county, and foundations can work together to fund comprehensive pretrial services. Your presence tonight leads us to believe leads us to believe that you want pretrial services to get better. Is that right? Is that right? To close this out, what we've heard is we can do together what we cannot do alone. We can do together what we cannot do alone. We can and will get better. Say it together. We can and will get better. Now let's hear our challenge from Reverend Dr. Joanne Zakoven. Thank you.
So again, let me thank each of our program participants for taking time to share the work that they are doing and the role that they're each playing in our current system of judges. And I want to thank each and every one of you tonight for being here and taking time out of your very busy schedules. But let me say to all of us, both on this platform and in this audience, it is not enough. It is not enough. And the reason it is not enough is because we know our system can do better, as Reverend Cruz has mentioned, and it is up to us. See, all of us have to play a part. And there are those who are crucial parts and more crucial than others within our system who are not here tonight. or they're not represented tonight, who we will also need to be a part of making our system more fair and more just. You see, our system is a reflection not of itself. It is a reflection of us. It is a reflection of generations of indifference and outright disregard toward those who are poor, those who are Black, those who are brown, those who aren't well connected, those who don't know someone, or those who don't know someone who knows someone who knows someone who can help them jury rig or avoid the jagged edges of the system. See, we know how the system works, and some of us have benefited from it. Some of us are blind to it. Some of us have done work to change it, as you've heard tonight, and some have made the problem even worse by doing more harm than good or doing nothing at all. All the while knowing, as the data clearly shows, as Ms. Ireland has pointed out, there are people sitting in our jails who pose no threat to themselves nor this community, and their only sin is their lack of net worth or the color of their skin. This is the system we have, but it doesn't have to be the system we accept. We can cause some good trouble tonight. We can cause good trouble over the course of the next series of election cycles from both within and outside of our system of justice by first shining light on every part of our system, from the time of arrest to when charges are filed, to the first court appearance when an attorney is assigned, to when risk assessments are made, to when bonds are considered. And those who want to be a part of building something better, those who want to be a part of the good troublemakers, we will recognize you, we will honor you, we will lift you up, we will vote for you. But those who want to keep the status quo, my charge to you is to remember them when you go to the polls in November and in every future election we have in our county. Let's remember them when they come to our congregations looking for us as voters to give them another term, when they are some of the harshest when it comes to giving people a second chance. Let's remember them, remember their name. Some might ask, why are we doing this? What does this have to do with me? I could be at home watching a Cavs game. How am I affected by this? But I ask you a question, how are we not? You see, in another time, in another place, this could be you or a member of your family, and you would only hope that there were some citizens from across this county of different races, religions, socio and economic backgrounds, banding together, speaking on your behalf, raising their voices for no other reason but because it is right. Tell somebody it's right. So, as is our custom in GCC, as a part of our training, we begin with education. Tonight, we begin with education. We have been educating ourselves over the last several months, meeting with many of our judges and many of our experts and researchers who are present here tonight. We have been educating ourselves, and we commit to continuing to educate ourselves on this issue by listening to the experts, the decision makers, policy shapers, and impacted families and individuals like Tiffany. But let's not stop there. Let's not be stagnated by what Dr. King called a paralysis of analysis. Yes, we will question, yes, but we will also challenge. We will push. We will agitate. We will impact change in the best of our civil rights, nonviolent, direct action traditions. And we will also imagine. Yes, we will imagine with our leading researchers, our elected officials, our court officers, and our community a better system which keeps us safe while also protecting all of our rights. So let us imagine and act together. And finally, let me ask a question. What do we have to lose? Or maybe the better question is, what have we already lost? From wrongful convictions in this county to racial disparities and arrests in this county, to indictments, convictions, sentencing, and incarceration, to criminalizing the mentally ill, to making our jails and prisons the warehouse of all the problems in our society that we cannot solve. Is it too much to ask our leaders to admit that our system is not perfect and has done inestimable harm? Is our commitment to what is and what has been so absolute that we will let one more person spend one more night in our county jail who all the data and indicators tell us they should not have to? Can we not commit tonight as leaders, as a community, as people of faith, as impacted families and individuals? We will not let the spark we have lit tonight flicker out like so many times in the past to fix what's broken. No more study after study after study after study after study after study. Can we do what needs to be done? Cutting the red tape, putting aside the personal political grievances, forgetting whether it's a D or an R, and do what's right? Can we bring the best minds, the best efforts, the best intentions to the table and imagine, my God, imagine and create to reform something that is worthy of those coming after us? And let me tell you, in closing, if we do that, it will be well worth our time, our debates, our disagreements, our back and forth, our push and pull, as Judge Early mentioned, because in the end, something better will have emerged. God bless you. Amen. Amen. Amen.
We can do better. Okay, we start on time, we end on time. I'm sorry, it's 3 minutes over. I have just two things to tell you. One, our goal was to have 500 people to participate in this tonight. We have 514 people. Number two, I can't dismiss you until you've completed your assignment. Did you finish your homework? Did you fill out the comments and commitment sheet? Please turn them in, okay? God bless. Thank you for being here.